associate at the Appellate Project. I'm an associate at the Appellate Project, and the team at TAP is so excited to be collaborating with the Public Defender Services for DC on this event. And before we get started, and I just wanted to share a little bit of background of the Appellate Project. Our organization was founded in 2019 by our executive director, Javeri Khan, and our mission is to ensure that our highest courts reflect our communities. Although the Supreme Court is the highest court in the nation, it only hears about 2% of the cases that it receives, which means that lower appellate courts are left to make final decisions in about 98% of cases. And the issue that we've seen that arises with that is that although decisions of these cases disproportionately impact people of color, these communities are often left out of the decision-making process. So not only are we excited to host this event today to support those who may be interested in pursuing a career in public defense, but to also encourage those from diverse backgrounds to see it as a career path for themselves. I know I've talked a lot about TAP, but if you'd like to learn more about our organization and the work that we do, please feel free to visit our website, which I will be dropping in the chat right now. On our website, if you scroll down, you'll be able to sign up for our listserv, as well as find information on how to follow us on social media and keep up to date on everything TAP. As well, you'll be able to find resources such as our clerkship handbook, which is a comprehensive guide on how to approach the clerkship process. And yeah, on our website, you'll be able to find other information on the work that we do. But like I mentioned before, this event is a collaboration with the Public Defender Services for DC. So I'd love to turn it over to our moderator for the discussion, Ariba.
Hi, everyone. Thank you so much for joining us today. We're so excited to have this conversation and to have all of you be a part of it. I am going to get us started because we have so much that you have all asked us to cover. And I know people will be trickling in, but hopefully everyone will be able to catch up as we go. So to just start off with, I wanted to introduce all of our panelists, and then we'll dive into the questions. Starting with Carrie Darden. Carrie is an assistant appellate defender in Chicago. She works for the Office of the State Appellate Defender of Illinois, where she has been working since graduating from the University of Michigan Law School in 2020. Fun fact, Carrie and I were in the same super section in law school. Next up, we have the wonderful Katrina Naharo. She joined the California Office of the State Public Defender in 2021 after spending 4 years as a trial attorney with the Maryland Office of the Public Defender. She graduated from Berkeley Law in 2015 and Columbia University in 2010. And finally, last but not least, we have Caprice Jennerson, who has over 20 years of experience as a trial and appellate criminal defense attorney. Among her many accomplishments, she currently serves as the president and attorney in charge of the Office of the Appellate Defender in New York City. Since 2019, Caprice has annually been named to the top 100 lawyers of the National Black Lawyers. So thank you so much, everyone, for joining us today, and really a special thank you to our panelists for being here with us and taking the time out of your day. So let's start with sort of the first question that comes into people's minds. How did you get into appellate defense work? And so, Caprice, maybe we can start with you. Tell us about your pathway into your role.
Sure. So, hi, everybody. So I would first say that my path to appellate practice is probably different and unorthodox than most people. So I did not do a clerkship. I did not do the criminal law clinics in law school. I did not do law review or moot court. So I did none of the things. I did not work in big law at any point in time in my career. So all of the things that you sort of hear about that folks say will help you get into appellate practice. I didn't do any of the things. But what did happen, I went to law school in Georgia and was just fortunate enough to be hired in my second year of law school as a legal intern and researcher for a prominent criminal defense lawyer. And it was just sort of, I knew that I wanted to do something in criminal law, and I just didn't know what. And I was always impressed about other law students who knew right away that they wanted to be a trial lawyer or an appellate lawyer or whatever. I'm like, how did you fit? What? I never understood that, but I've just sort of built relationships along the way that have sort of created opportunities that aligned with values that I had. And so I'll tell you a really quick story about why appellate practice became important to me. I started, as I said, with this criminal defense lawyer when I was still in law school, and became his associate and senior associate, just worked up through the ranks. I worked in his office for over 12 years. But probably second year into his office as an associate, we had a client who she should never have had a driver's license, I'm sure of it. She had so many sort of traffic violations. All the time she had traffic violations. But at this particular time, she went to court without a lawyer. And she'd had so many violations of varying sorts. The particular judge was going to sentence her to jail time. And this is the first time in her history that she was ever going to be sentenced to jail. And thankfully, he didn't sentence her. He didn't put her in jail that same day. And she came to us and she wanted us to withdraw her guilty plea. And researching and trying to figure out, well, how do I help this client who was really, a part of our office because we represented her so often. And I started this appellate process to sort of reverse her guilty plea, to take back her guilty plea. And as it turned out, in the state of Georgia back in the 90s, and now I'm dating myself, but back in the 90s, misdemeanor courts did not have to keep a verbatim record of guilty plea proceedings. You could just have the accused person sign a document saying, I agree to plead guilty. And that was the record on appeal. And so that's what I was appealing, that there ought to be a verbatim record of the appellate of the process below so that the person could appeal. And so my boss thought it was sort of a throwaway issue. And so he just let me run with it, which was good. But also I was like, I've never been to the Court of Appeals or the Georgia Court of Appeals, which is the highest state court in Georgia. I had no idea what I was doing, but he matched me with some other appellate lawyers who sort of gave me some tidbits along the way. And ultimately, the Georgia Supreme Court ruled in my favor and changed the law in the state of Georgia that misdemeanor courts had to have verbatim records, which was like a big deal. And so that what turned out was a little thing, perhaps not a little thing because liberty was at stake, but turned out for me, it helped me to see that what's coming out of the appellate courts really do affect individual lives, but also larger communities. So that was sort of a big deal. And of course, Miss King, my client at the time, was a woman of color. And so it sort of really made me think, appellate practice is bigger than what I knew it to be. And I can actually impact how laws are being interpreted and how they're going to be applied to people's lives that look like me. So that was sort of how I got into that. And for many years, I was still a trial lawyer, but I would take, selected appeals that came up along the way. And ultimately, I decided, I think I like appellate work better for a host of reasons. I think I'm just far more cerebral than I am, sort of the rigorous trial sort of practice. And we might get into this later, but I was also a single mother. So just trying to figure out work-life integration was also a big deal for me. And trial practice and appellate practice is very different. So I had to sort of figure that out for myself. And ultimately, maybe 6 years into practice, I switched to doing appellate practice pretty much. I didn't try very many cases after that. So that's sort of my pathway, as I said, very different, but that sort of was the spark for me. And I was just fortunate to have built community in Atlanta where there were lawyers who took me under their wing and sort of talked with me about what appellate practice looked like, how to write a brief, gave me a bunch of sample briefs to read and sort of got me started in that way. So that's sort of how I got kicked off in it.
Awesome. And thank you so much for sharing that. I think it's so helpful for people to hear outside of law school that the way lawyers are reaching their goals is not exactly how that straightforward path that you think people are telling you in law school. So I guess maybe we should go back there. Carrie, you definitely, I think, knew from the beginning that you wanted to be a public defender and even really that you wanted to practice in Chicago after law school. What was it like navigating that as a student and making sure that you would have a job lined up after you graduated?
Yeah, so I definitely came into law school knowing that I wanted to be a public interest attorney and knowing that I was primarily intellectually interested in criminal law and the intersection of constitutional law and criminal law. And I knew I wanted to practice in Chicago. And so for me, that meant either the Cook County Public Defender's Office or OSAD. And so I interned at OSAD after my 1L year, and I interned at the Cook County PD's office after my second year in law school. And I think, to back up for a second, I think I sort of, to your point earlier, kind of had sort of like a narrow understanding of what a public defender really looks like. I didn't realize actually that there was a group of attorneys dedicated to representing someone after they've been convicted, and that could be a totally separate practice. And so when I found out about OSAD, I think, like many law students, I figured the best way to figure out if it was something that I could see myself doing was to intern there. And I got a really clear understanding of what it was like to be an appellate attorney when I interned at the office. And I think the same thing was true when I worked at the Cook County PD's office. And there were things about both that appealed to me, no pun intended. But ultimately, I think, to Caprice's point, the work-life balance and the more predictable schedule and the more consistent schedule was something that seemed so foreign to the messaging that I was getting in law school, because in law school, I feel like what I was sort of believing was that, being a lawyer is supposed to be your entire identity. You're supposed to be always on the clock. You're supposed to be always like thinking about the law, dreaming about the law. It's supposed to be like consuming every waking moment of your day. And then I interned at my office and I saw, attorneys who were leaving work early to go to a baseball game with their kids, or who were taking like 2 weeks off in the summer to take a vacation. And I think as a result of that flexibility and the work-life balance, I also saw several attorneys who'd been with our office for like 30 years, 35 years, 40 years. And so that longevity, I was really interested in that, because I also thought that, lawyers are supposed to bop around from place to place forever, indefinitely, until you retire or die, I guess. And so I think I'm really interested in the work itself, but I think the things outside of the work is what made me realize that appellate defense was probably a better fit for me than trial practice. I think also, as a woman of color, representing people who look like me and sitting across from someone every single day and talking to people in detention and going into the jail on a regular basis took an emotional toll on me that I wasn't expecting. And one of the benefits for me in being an appellate defender is I can still represent, communities that I care about and identify with, but at a bit of a distance that helps me maintain some semblance of mental health and stability. So that's sort of like a roundabout way of how I ended up here.
Thank you. And thank you so much for sharing that. I think people can sometimes underestimate the impact of the work, or maybe even overestimate it. And this is a good way to kind of balance skill and what it means to actually do the job. Christina, finally, can you tell us about your pathway and how you got to your role today?
Sure. So I came into law school knowing I definitely wanted to do criminal defense work, but I just wasn't sure what that looked like. I thought it would look like maybe habeas work or post-conviction work. I had worked at the Innocence Project before law school. And, of course, when you're in law school, everyone's like trial, trial, trial. And I hadn't really tried it out. In law school, you're kind of protected. And I kind of thought, well, I'll try it and see how it goes. But appeals were kind of like the last thing on my mind until I did a clinic where I worked on an appeal. But I tried trial work. Respect to those who can do it. I think I really enjoyed it. I learned a lot from it, but I decided ultimately it just wasn't for me. It wasn't my skill set. It wasn't my ability to handle stress well, all of those things. And so I was kind of thinking about transitioning after about 5 years doing trial work, and a job opened up here at OSPD where I had first kind of done my appeals in law school. I worked with an attorney here, and that kind of led me back here. And, I did always like research and writing. I did always like being able to take my time, getting to know my clients, all of those things. And so OSPD does capital work, capital appeals. And so our caseloads are quite a bit smaller than perhaps people who are doing like non-capital appeals. And so I think, and they last a really, really long time, like years. So that kind of appealed to me too, being able to really delve into issues and really, you know, develop a strong relationship over many years with your clients. And I think ultimately, like, as you know, and kind of what Carrie was saying, like, I'm glad I can do this work because I'm extremely passionate about it. And it's something I do because of, you know, my family and my background and my growing up and my family experiences. But I also couldn't be on the front lines. That's just not the place for me. But I think, you know, an appeal is an incredibly important part of this process. It's kind of maybe even the last time a person will have an attorney to work with them and to be on their case. So I think that it's just as important. And even though it maybe doesn't feel like when you're in law school, everyone's, oh, we have to be, you know, on the front lines, you know, digging in trial work. It's not always what you're meant to do. And so I definitely think understanding that, recognizing that is kind of what brought me to appeals. I mean, I really, really love this work. I'm, you know, grateful every day that I'm able to do it.
Thank you. So it sounds like a common theme kind of that's emerging is that appellate work wasn't necessary, especially criminal defense appellate work, wasn't necessarily something that you came into law school knowing about or had opportunities early on in law school to work on or get familiar with. So just for everyone in the audience who maybe saw the title of the panel and thought that might look interesting, but wasn't exactly sure what that work was, can you tell us, maybe we'll start with Caprice and then go to Carrie and Christina to talk about how it's different in your jurisdiction, but can you tell us first what appellate defense work is, and then second, how that works in your office?
Sure. So I suppose in a nutshell, you know, when folks have concluded a case in a trial court, whether by trial or guilty plea, in all jurisdictions, you have an opportunity to appeal your conviction to a higher court, to challenge where you know, whether there may have been errors at trial or a sentence might be, you know, you might want to challenge a sentence, but to challenge some aspect of what has occurred below. And so then the appellate process begins, and that looks different in different jurisdictions, even whether you have the right to appeal or whether it's an interlocutory appeal or whether it's a discretionary appeal, that sort of varies by jurisdiction. But generally, once you're in the appellate court, even the structure of the courts are different by jurisdiction, right? Like what's your highest court, your state court in a particular jurisdiction. In New York, it's the New York Court of Appeals, and Georgia is the Georgia Supreme Court. So all of that is sort of different as well. But for the appellate defender, you are examining what has occurred below to really challenge whether the outcome of that trial or guilty plea was fair, and following applicable laws. And that's not the easiest of all things to do, right? Because if you were not the trial lawyer, now you first have to get familiar about, well, what happened at trial? So you have to, and not maybe just not at trial, there may have been evidentiary hearings, there may have been suppression hearings and other types of hearings in the lower court. And you're trying to piece together a picture of what occurred in the life of this case before it gets to your office. So you're gathering transcripts and other court papers. You may be talking to the lawyer who represented your client below. And then of course you're talking to your client directly and then trying to piece together this larger story of what happened at trial. I think probably one of the first things, once you started gathering all of the information and reading all of the transcripts, an appellate defender issue spots. So we're trying to pick out what we think are the relevant issues that we want to challenge and that we want to bring to the attention of the appellate courts. And issue spotting is, could be evidentiary, could be fact-based. It's sort of, you know, I think, in my opinion, you get to know what the issues are once you understand criminal law, criminal procedure, evidence issues, all of that you have to kind of know and wrap your head around to even determine what the issues are. And then what's the story? Like, how are you going to tell the court about these issues? And that also then courts vary about that in terms of the style of the written brief. That first step is taking all of the information that you've pulled together and writing an appellate brief. And the structure of that is usually dictated by the court. But in all cases, I think as a defender, you're trying to tell the story of your client, right? Using the facts and the law, but you're still telling your client's story. And most of the time in the criminal context, our clients are vilified. They're seen as the worst people. They've done the worst things. So by the time they get to the appellate process, society has typically closed the door, and you're saying, open the door. My client is a human being. There's a story that I want to tell you about what has happened here. And that's sort of the appellate, what you want to get before the court. And then in most courts, you also have the opportunity, in addition to your written submission, is to present oral argument. That was like the thing for me. I love the writing part, but oral argument was like, if I could have done that every day, I probably would still be doing that if that was a daily function. But it varies how much time you have to stand before the court. So again, it's this exercise in thinking about, what do I want to present to the court? How much time do I have to do it? And how do I get across introducing my client to the court and what their issues are, and trying to persuade the court to reverse a conviction, vacate a conviction, remand a conviction for maybe resentencing or some evidentiary hearing. And then there's even the piece beyond that, which is the post-conviction, which is still a part of appellate practice, which is after a particular person has exhausted, right, their appellate remedies, there are still some post-conviction avenues that are sometimes available, whether through habeas corpus, whether it's clemency, different ways that we still might be able to advocate for the client. And so, as Christina was saying, there's still, even in non-capital cases, it's still possible that you are representing your client for a number of years through all of these different avenues. And some jurisdictions do give you the ability to bring cases back to court. There are cases that you find that it could be a wrongful conviction, not just an error at trial, but an actual wrongful conviction. And lots of jurisdictions give you ways to bring those cases back to court. So it can be a very complicated process, and certainly one that people need representation. It's always interesting to me to see people try to navigate that process for themselves as a pro se litigant, and also pro se while in custody. And try to navigate that. And so many people do. And so then thank God for public defender offices that people, especially those who don't have the resources to afford appellate counsel on their own, can have someone assigned to them to really sort of dig through a very complicated process. And all of that is really to tell stories for our clients, which, through my sort of career have largely been Black and brown people, largely men. Currently you sort of see an uptick in women also facing long criminal convictions, but largely men, Black men. And so really sort of seeing this dynamic over a period of time that, communities of colors have been over-policed and over-criminalized, and really trying to figure out, as you're representing this one client, can you have impact on these larger systemic issues, right? And trying to figure out, can you do that through these particular cases that you're representing? So that's how I sort of summarize the appellate sort of process in a nutshell. And I'm sure others have sort of a different way of looking at it.
Thank you so much. That was a very eloquent explanation of a very complicated whole system. And you really broke that down so perfectly for us. Caprice and Christina, Carrie and Christina, do you have a different thought process in how this works in your practice or in your jurisdiction?
I think we're largely aligned in terms of jurisdictional differences. We handle direct appeals, which is immediately after someone's been convicted, you have the opportunity to file a notice of appeal, and your direct appeal comes from your trial or guilty plea. And then our office also represents people who have filed post-conviction petitions, which is our state version of habeas corpus. And so that's after someone has exhausted their direct appeal options and yet they still want to raise challenges to their convictions. In Illinois, and I think in most states, our direct appeals are limited to the four corners of the trial court record. And so if there's something that happened outside of court, whether it's a conversation with your trial attorney, an alibi witness that wasn't presented, or whatever the case may be, that's not going to appear in the record. So it's not something we can raise on direct appeal. But in a post-conviction proceeding, that's something that our clients can raise. And so we do handle a lot of appeals right now after COVID because we're still kind of lagging from decreased jury trials. We are actually probably like 60% post-conviction proceedings and 40% direct appeals. And so we can help a client navigate the appellate process on that front too. Unfortunately, the statute that sets out post-conviction law in Illinois requires our clients to file their petitions pro se. And so a lot of times we're working through, 90 pages of handwritten text where our clients are doing their best to raise, what are sometimes very complicated legal issues. And so it can be kind of sort of like figuring out how to weave together the pieces of a puzzle and try to do your best to present your client's claims in, a way that the judges you hope will appreciate. And so I would say what my day-to-day might look like, just on a more granular level. If I get a case, I start reading the transcript and I take notes. And a lot of times my notes are just gut checks. Like if the prosecutor had a crazy closing statement and I might write in the margins, like, did she really just say that or something like that? And then I can go back and figure out if there's like a valid legal basis to raise an issue there. And then I'll write up an issues conference form where I talk about all the possible issues. I'll talk about it with my supervisor or another attorney, and then talk to my client, explain what I think are viable issues, and figure out, if those are issues that the client would be interested in me raising. Then I'll write a brief, file the brief. The state appellate prosecutors get an opportunity to respond, and then we file another written response, basically disagreeing with whatever they said. And sometimes we get oral argument. I think that can be a jurisdictional difference. In Illinois, I practice out of the first appellate court district, and they choose cases in their discretion. So we ask for argument in every single case, and we only get them in about maybe 10% of cases. In the lower or in the downstate districts, you can ask, they'll basically grant you argument in every case you ask for it. So those attorneys have to exercise a bit more discretion to figure out if they think a case would benefit from oral advocacy or not. But usually we don't get oral argument and the judges just decide the case on the briefs. And then we sort of go from there and figure out if there's anything else we can do to try to further appeal the case. But that kind of gives you a sense of what it's like in Illinois, at least.
Thank you. And Christina?
Yeah, wow, you guys did all the heavy lifting of explaining, so I can just kind of pepper in. In California, it's somewhat similar. We, OSPD handles capital cases, but we do take some non-capital cases for training purposes, so people can become death qualified to handle death penalty cases. Direct appeals, we only handle appeals though, so that is a difference. There's a totally different organization that handles capital habeas. As far as non-capital habeas, that's a whole other problem. But we do not handle anything outside of just the straight appeal. And then for non-capital appeals, the majority of those cases go to what are called projects throughout the state, and they give them off to panel attorneys. So it is a panel attorney system in California for the most part. And the projects are kind of overseeing, providing guidance, providing help, but it is generally a much more like independent practice in California. We also have a lot of, obviously, trials, but we have a lot of, California has had a lot of ameliorative legislation for people who, were subject to the 3 strikes laws or really, really punitive sentencing. California has passed a lot of laws to correct that. And those people go to the trial court first, file a petition or ask for resentencing or some kind of relief. And when they lose, they can appeal that. And so we do get a lot of appeals. There was a change in the murder law recently, so a lot of people are getting relief for felony murder if they were not directly, there's a lot of, I don't need to get into the laws of it, but it has really been helpful for people. So we see a lot of those appeals as well. And I think, one thing I'll just, well, as to how we get cases at OSPD, we do take them on. We are the legislatively mandated to take capital appeals. Unfortunately, there is an incredible backlog of cases because they are so complex and so complicated, and they take years, decades. So we do take new cases. Some go to panel attorneys as well, conflict cases, but there's a huge, huge backlog in California. And so it's a slow process for sure. And then the only other thing I'd want to say, which both Carrie and Caprice mentioned, issue spotting. And I think it can kind of feel overwhelming when you're thinking about going into appeals, like, how will I learn all this? Like, how will I get the law? How can I read a transcript and know what's wrong? But the gut check thing is so real. You're reading something and you're like, this is not right. There's something off. And you don't know what it is. And you may not, especially as a young attorney, recognize it or know that there's, decades of case law about it, or sometimes maybe 2 or 3 cases about it, but something's off. And I think the beauty of appeals is you don't need to come in with like this world of knowledge of like, oh, I know everything about criminal law and everything about criminal procedure. You take each case as it comes. So you do your gut checks, you do your kind of, this seems off, this seems weird, here's an objection, I'm not sure why. And then you do the research, and then you get the time that trial attorneys aren't always afforded. So I will say that's something I love about appeals, is that you can feel what's off and then go and do the research and the work and figure out how to articulate it in a brief.
Thank you. We could probably spend a whole hour talking about appellate work and the differences between different practices in different jurisdictions and people's different personal pathways. But I think this gives you kind of a taste of how different appellate practice could be in a different jurisdiction, and all of the different types of pathways that you could take to be able to get into this position, which hopefully kind of dispels some of the myths that you might have come into this panel here thinking about. So going from that, I'm sure now all of you want to be appellate public defenders, and you're thinking about how to get there. So starting with Carrie, since I know a lot of people in the audience are law students right now and thinking about maybe how to get here in a year, like when you're done or once you've graduated. Can you tell us, Carrie, about the things you did in law school that helped prepare you to be an appellate public defender? And really particularly what skills that first year in the job, when Carrie and I graduated around the same time, I can tell you I was so nervous my first year of practice. What were the things when you were in law school that, or like when you were in your first year of practice, that you could think back to from law school and think those things really helped me? And what were things that people had said you should really do if you're considering a career in appellate defense that maybe weren't as helpful?
Yeah, so I think if you did no extracurriculars whatsoever and you just focused on your law school coursework, you'd be perfectly prepared to be an appellate defender. I think this is, let me add the caveat that I don't think law schools always do a great job of teaching people how to handle client relations, but that you might not get that in law school anywhere, no matter what you participate in. Obviously, clinics, that may be an option there. But as far as like the tangible legal work, the research, the writing, it's, to me, in my experience, very much mirrors a lot of the things that we learned in like legal writing, for instance, figuring out how to, maybe the issue spotting is a little bit different in a criminal context when you're dealing with someone's actual case. But the broader skills about researching and writing that you're getting in your legal writing classes. I also think for me, I did a journal when I was in school, and at the time I thought I was doing a lot of grunt work for no pay and very little payoff. But I realize now in practice that it made me very detail oriented. And I think when you're, I just finished writing like a 50-page brief, and by page like 25, your eyes are kind of glazing over and it can be kind of hard to focus on details. And I think the skills that I learned in law school on a journal helped me be able to spot, typos. I have like a strange ability to identify an unitalicized period as a result of it. And I think it's just made my briefs pretty clean because I tend, knock on wood, not to have a ton of errors because I can all the years of site checking, I can kind of pick those things out. But again, I don't think that's something that's necessary. As far as the oral advocacy component of it, I think that part can be pretty intimidating. And if I could go back and do things differently, I may have done something like moot court or even mock trial, just to get more comfortable speaking in public about complex legal issues, because public speaking in front of 3 appellate court judges who are asking you questions about a case that you barely remember is, like a case that you cited a month ago or a case that you maybe cited a year ago when you originally filed the brief. That is a different skill. And so I'm grateful that my office has some training for stuff like that, but if I was practicing in an office with less training, I think I probably would have benefited from having more practice doing oral advocacy in the appellate context, because I think it's kind of a specific skill. But like I said at the beginning, I really want to emphasize, you don't have to do a journal, you don't have to do moot court, you don't have to do any of those things. If you're passionate about the work and you're interested in, doing your best in your coursework so that you can learn the issue spotting, you can learn the research, you can learn the writing, you'll be more than, prepared to start a career as an appellate defender right out of law school.
Thank you. I think probably the oral argument piece resonates the most for me, as I very nervously moderate this panel. So going from there, Caprice and Christina, do you have some thoughts maybe on when you're hiring? It is pretty rare. We kind of talked about this earlier before we logged onto this panel, for relatively junior attorneys to be in an appellate role. What are ways in which law students can stand out and try to get into this position right after graduation?
Sure. So I would advise folks to sort of do their research, especially if you're not tied to a particular state or jurisdiction, to sort of research what offices are doing in terms of hiring. So for instance, my office does hire directly out of law school, and intentionally so, because we consider ourselves a training office. So we started that, and there are a lot of other reasons why we do so, and also about diversity. It's like trying to encourage more students of color to enter appellate practice. So we do hire directly out of law school. And I do think that there's some things, as to what Carrie was saying, and I think people sort of think, well, God, I didn't do this particular thing. I didn't do this type of clinic. This is not for me. And even from the hiring perspective, in my office in particular, we try to check ourselves, like, yeah, we're looking for this kind of stuff, but also, should it exclude people? Are there other ways to get to this? So I do think when folks are thinking about like applying to an appellate office, you always have to send the writing sample and all that sort of thing. But I even think your cover letter is a chance to show how you think and how you write. So the sample brief that you send is important, but I really do spend a good amount of time reading the cover letters, because I think you get to, see how people introduce themselves and what they think is important that's not in a resume and not in the writing sample. So that's sort of, for me, is sort of an important avenue. But I agree with Carrie that there's no sort of set way. And I think if you've gone to law school and you focus, I do think you should focus on your legal writing class, because the writing piece is really big in appellate practice. But I think all of it you can learn. All of it you can learn. And in most offices, there's some sort of training practice. There's some sort of buddy system. There's something that sort of helps you hone your skills. I will tell people to do things that I think might be a little unorthodox, because that's just me. I'd encourage folks to take an improv class. That has nothing to do with practicing law, but it's sort of, you stand up, you have people throwing things at you. What would you do with this box of cookies? This box of cookies is your friend. Introduce your cookies. So you're just sort of talking, right? it really does sort of loosen you up, because the thing about oral advocacy is that you're just scared to death. That's, you know, the case, you know the law, but you're scared to death because you have, Carrie put it nicely, she said, when the panel of 3 judges are asking you questions, they're not asking. They're throwing torpedoes at you, like, you know, and they're rapid fire, and you're answering one question and the other justice is already asking you something different. It's difficult. But that's sort of, I've tried this improv thing, and other people that I know have done it, and it's still, you know, it just gives you the sort of, I can stand up and talk about anything sort of feel. I think the other thing that I tell people is I read everything, not just appellate briefs. I read a little sci-fi, I read a little romance, I read a little, but I find that's really helpful when I'm developing language of how I'm going to describe, you know, the facts of the case, or what spin am I going to use? What art of persuasion am I putting on my appellate briefs? I find that words pop up in my head that I'm like, oh, that's a good one. But that's because I read everything that have things that have nothing to do with the law. So if you have time, and I suggest you make some time to sort of broaden how you think about things, because it helps with that writing piece. One thing that I do not like is sort of the robotic formulaic sort of briefs. Like, I know we have to follow certain structures, but there are some briefs that at some point it's hard to keep reading. Like, you've lost the reader's sort of attention because you're just sort of robotically moving through, and I just think having some sort of I call it flavor, but it's something that you sort of get when you open your mind and you're really thinking of different ways of explaining things. And I think that's really important when you think about how many appellate briefs are going into the court. You want yours to stand out. So when the clerks and the judges are reading all of these briefs, what's different about yours? Like, you've got to use the same font. You're doing issue, rule, analysis, conclusion. Everybody's doing that. So what makes yours different? And usually that's your language. Usually that's the words that you're using in your statement of facts and how you are, you know, framing the questions presented. That's going to get somebody's attention and want them to keep sort of reading. So, but that's something I think you should sort of pick up. And it's not something that law school is teaching anyway, I don't think. So, you know, if your interest is in appellate practice, I just think you take all of the things and sort of bottle them up and try to use them as best you can. And I think also the last thing I'll say is just build relationships with people in appellate practice, out of appellate practice, in corporate law. You would be surprised the things that you learn and the resources that are there that'll help you get into a practice that sometimes feels pretty elitist and pretty exclusive. You can definitely find your way in, and that's relationship building. So to keep that in mind too, about networking and building relationships across practice areas.
I do think in California it can be hard to break into appellate practice, just because of our panel system, and the fact that you're kind of on your own right when you start. You know, OSPD, my office, does have a fellowship program. We're hiring this fall. If people are interested, you can go to our website. We take 2 fellows, and it's a 2-year fellowship where we really do an intensive training program. I know other projects are also taking on attorneys to work in the projects rather than being a panel attorney. You work in the project that oversees the panel attorneys. You take on your own cases and you get trained that way. But it can be really, really hard, I think, and difficult. But I think people are also realizing that it is hard and difficult in California, and that we need to make it more accessible to people. And we don't have the benefit of having a public defender system like New York and Illinois, it sounds like. So we are trying to be as inclusive and outreaching as possible. As people are getting older and retiring, you know, our clients need good representation. I would also just definitely agree with, you know, I think anything can be good experience, right? Like, the thing about being a lawyer is you are an advocate. And so you should be able to advocate for yourself in interviews, on cover letters. If you look at it that way, I think it's a lot easier than saying like, oh, like I have to spin my experience doing this into appellate work. It's a very niche area of law. I mean, maybe it's not, but it's hard when you can't point to an appellate brief you filed. And so advocate for yourself, find ways that your experience can speak to what this job is. And there are many ways. I mean, writing, research, understanding of law, being detail oriented. I studied creative writing in college. Like, I think that informs, as Caprice was saying, informs my work every day. So learn how to advocate for yourself if this is a job you want. I think what it requires is dedication to the work, to public defense, to our clients, to remediating the racism and injustice that is in our system, and an interest in writing and research. And the rest can be taught. I also very firmly believe that the rest can be taught, as long as you have the passion for the work. So I don't think anything would foreclose this kind of work, nor there are some things that are helpful for sure, but I didn't clerk, I didn't do law review. But I think people's different paths kind of lead them to where they should be, hopefully. And if any of this is resonating, I think you guys should definitely go for it and try to see if appellate is for you and is something that you'd be interested in. I think that's everything I had to say. Everyone just says so many things. I want to respond to everyone's thoughts, but I think that's it.
Thank you. Okay, so I think for just the next set of questions was going to be about transitioning from trial to appellate. We're pretty short on time, and I think a lot of people have already covered, the panelists have sort of already covered what types of skill sets one could build in a different job to then transition into this space. I personally have had big law experience. I have had civil rights fellowship experiences before transitioning into this role. So there's definitely a lot from what Carrie, Christina, and Capri said that I pulled into and spun to make that kind of transition. And I think a lot of people can. But there's one question that really stood out in terms of what people were feeling. And I guess two. One, do you have to have clerked? And two, can you do this job even if you have big law on your resume? And so just very, very quickly, can you tell me a yes or no? Do you need to have clerked, and can you spin your big law experience?
You do not need to have clerked. I do think it's varies so much, though. It might depend on which office you're applying to. Like if you're talking institutional provider, I think that depending on who's in leadership, might be a different thought process about that. In my office, it's not a necessity that you have clerked. Do I think it helps sometimes? Sure, I think it helps sometimes, right? But I think there's so many things I'm looking for. And like others have said, for me, it's more about dedication to the work. It's more about, I think sometimes I'm looking more about lived experience, about, what folks have sort of seen, in their lives that lead them to this work. That's always more interesting to me than whether you did a clerkship. I don't think big law experience hurts, because I think there are some skills that you learn at big law firms that is interesting. But I think one thing, if you're at a big law firm, I think you should do pro bono work, because I think that's the piece of it that is really interesting. So you can choose, if you're trying to move into a criminal appellate defender office, you could have probably gotten some of that experience doing pro bono work with your law firm, because most now have connections with nonprofits that are doing this kind of work. And even if not specifically appellate experience, there are all sorts of nonprofit opportunities or pro bono opportunities that sort of give you a window into the experience of people experiencing poverty, because that's really all of our clients are experiencing poverty in these, and that's a really important thing to understand, the intersection between criminal law, constitutional law, and poverty, and why our clients are where they are and how they got there. That's really important, I think, to really have the mindset that the criminal legal system in America is deeply racist. It just is. And if you start from there and then start to sort of, think about where you fall, what your values are around that, and you can, you can express that. So I don't think whether having a clerkship or big law experience is a hindrance, or even the thing that's going to get you, to get you there. I think it's a combination of other things. And I think it's so specific to where you practice, what office are you applying to, who's in leadership, what is the vision of the particular organization that you're applying to. It's just it's so varied. So I think you really have to just sort of do your research and reach out and Yeah, it's hard to answer that in a concrete way for so many other practices.
That's perfect, because that kind of, I think the theme, hopefully, that the audience is taking away is that this panel is really just your beginning. There's only so much we could cover in a short amount of time. And if there's a specific office that you really want to work in, or if there is a specific area, then you should definitely just reach out to people in that office to get more of a sense of exactly what they're looking for and how you can get there, even if you don't think you're going to make that transition straight out. Now we're very much like close to the end of time, so I want to turn to the live Q&A. So if anyone has questions, please put those in the chat. But for now, maybe I'll start with this one. I think a lot of people are often concerned with the emotional and vicarious trauma that can come from being a public defender. So is that something, I'll just read their question. Is it difficult to do this line of work knowing that most convictions don't get overturned on appeal? I'm curious about the emotional/vicarious trauma aspect of this, especially compared to being a trial PD, where the rates of getting a non-guilty verdict are, I assume, higher than the rates of successful appeals. Thank you so much.
I had unmuted to say one more thing about big law experience, which is I want to also acknowledge that people who go to big law may have to do it for financial reasons. Obviously, people of color are more affected by that. And any office that doesn't understand that that might be a reason why you went to big law is probably not somewhere that you want to be anyway. So I think that's another thing about big law experience. It should never close the door to this kind of work. But as to vicarious trauma, and it was a big adjustment from trial work. It was a huge adjustment because I did lose a lot in trial work, but I won a lot in trial work as well, relatively, right? And so one not guilty or one dismissed case or one suppression hearing could carry me for months. And that was happening pretty often, right? Like I'd get one out of every 15, 20, I'd win. But now the losing is constant and there's just fewer cases for which I'm getting any outcome. So it's a lot harder to sustain. And I think offices should be attuned to people needing support and talking about these things. And you should be talking to your colleagues who've been doing this work for a longer time. But it is extremely difficult. And I think anyone who does this work will go through periods where it's really hard. But self-care is important, and kind of finding what you can focus on, the bigger picture or the smaller picture, whatever it is, you need to kind of find your reason why you're able to keep going in the face of continual injustice and racism and all of these things. You have to find something. That might be a little too not concrete. Hopefully others have more thoughts.
I think it was the right answer, Christina. I absolutely think it was the right answer. I think I stopped counting wins a long time ago. One, because there weren't enough of them. And two, I just had to redefine what success meant. And so in appellate practice, this is not the number of wins. I had a client one time that his parents were hiring my firm, and he asked about, I was in private practice at the time, and he asked me, well, how many cases have you won? And I said, at the moment, this year, none. Like I was and I said, so if you want someone who's won a lot of cases, you're not going to hire me. But if you want someone who is going to fight like hell for you, then you should hire me, because that's the meaning of this for me, is that I dig in, I claw, I am not afraid to sort of tackle really difficult issues, whether it's in trial court or the appellate court. I'm not afraid to say race or racist. Like I'm going to tackle the issues around those difficult issues if that's what is necessary in a particular case. And, I represented that young man and got him home. And so I said to him when he finally came home, I said, look, there's one, I got one win. But I do think you have to redefine for yourself what success is. Appellate practice is extremely hard if you are looking for wins. Then that's not necessarily the right, this won't be work for you because you're not going to win as many as you would like to win. But I do think that if you're thinking more about the number of people who just need help that you could give, and you have the right skill set and attitude to sort of help people through this very difficult process, then that has to be more of the focus. And I do think what Christina said about figuring out what self-care is for you. And that's very different for different people. And we know public defense doesn't necessarily pay as well as as a big law or other corporate positions. So you've got to figure out what is modest self-care, right? But along the way, I've figured out like I am a huge spa person. I don't go to very expensive spas, but I get a facial. I tried acupuncture, love it. Like I've figured out that there are some things that I can do that I take care of me. I get my nails done. And that's just sort of like a simple little things that I do that I take care of me so that I can sort of navigate, that process where you're representing someone, and if you don't win their case, you know that they're going to spend the rest of their life in prison. So it does definitely weigh on you. I don't think I want to sugarcoat it, but you've got to focus on something other than that, because in your relationship with the client, if that's your focus, then you're also sort of weighing on that experience with the client. They already know what they're facing. And so that you need to have a different perspective about how you're serving and what that service means.
Yeah, I completely agree. I've been with my office for almost 4 years, and I can count on one hand the number of cases I've won. And there are times when that's really hard. But I also have found that having positive client interactions can sustain me more than I thought they would. Like recently, I had a client tell me that I'm the first lawyer who's really listened to him about his case. And, you know, even if we lose his case, which we most likely will, given the odds, I feel good about the fact that I was able to listen to him about his case and, you know, treat him like someone who deserves to be listened to. And I use when I'm, feeling sad about the cases that I lose, I try to remember that, I'm having an impact even if I'm not winning cases. And so for me, sometimes that looks like hanging up positive client letters in my office so that I can look at them. I've had a few clients send me like Christmas cards and things like that. I hang those up so that I can look at them to try to carry me through when I'm reading losses, because it's hard, but there are positives that you can find if you're looking for it. I think that's true in all types of work, but I think it's especially true in the kind of work where we lose a lot.
Thank you. And thank you so much for putting such a positive spin, everyone, on what can be a very difficult job. We are very much out of time. We've got 1 minute left. So I'm going to turn it over to Georgette to close us off. I'm so sorry to everyone for not being able to get to more of the audience questions and give everyone a chance to give final thoughts, but ending on, I think, a positive note of like how to keep going in this in a longer career, I think is really like a great place to kind of end this conversation for now. And of course, everyone is happy and ready to be available for questions or other interactions outside of just this panel.
Awesome. Thank you, Reba, for being such a great moderator. Thank you to Caprice, Christina, and Carrie for sharing your insights and your advice. As Reba was mentioning, they're all here and available for any questions. They have kindly offered their email addresses, which I will drop in the chat right now. So feel free if you have any follow-up questions or anything that came out of this conversation, we encourage you to reach out to them. After the Zoom today, you'll receive a short post survey. We asked if you guys can kindly fill that out. Your feedback will help us better understand how to improve future programs like this. So thank you all so much for joining us today. And yeah, I hope you have a great rest of your day.
Thank you,
Thank you.
everyone.
This was great.
Yeah, thanks.
Thank you.